Hello, Kelly Blatnik with Blatnik Law here. In a recent video, I discussed issues with settlement regarding non-disparagement clauses and confidentiality clauses, because typically those are the two clauses that clients have the most problem with, meaning that clients want to go out and say things about how much money they got or say bad things about the other side. And the confidentiality clauses and non-disparagement clauses prohibit either party from doing so. I had promised that in another video I would talk about compromising a minor's claim. What does that mean? In the state of Nevada and Clark County, Nevada specifically, we're looking at NRS Chapter 41, Section 200. NRS Chapter 41, Section 200 talks about compromise of a minor's claim, which is a really weird way of saying is that if a child or someone who's not reached the age of majority, which in this country is 18, and it specifically states in NRS 41 that it is an unemancipated minor. So if a minor has been emancipated and are able to act like an adult and have a court order saying that that minor is an adult, this statute does not apply. But for all those other minors who are not emancipated, this chapter and statute applies. The chapter and statute provides some oversight so that a court must approve the settlement sum. So imagine mom, dad, or two parents of non-binary gender are in an automotive collision, and in the back seat was their child, and the child had an injury. That is a personal injury that's personal to the child. The money for compensating for the personal injury should not be going to mom and dad, or mom and mom, or dad and dad, or whatever type of couple that are the parents of this child. The money is for the child. And unfortunately, we have a long history in this country and others of parents using the money that the child should have kept and received. Things like the care and maintenance of a child, if it's the ordinary care and maintenance of a child, food, clothing, shelter, those are things that parents are obligated to provide. Now, if the automotive collision or injury case causes the child to have increased needs, such as an in-home nurse, or they have to live in an assisted living facility, the increased needs are able to go to the parents with permission of the court to pay for the difference between what the ordinary expenses of raising the child would be and the extraordinary expenses are due to the physical injury to the child and the increased medical needs. So let's, in this scenario, opine that mom, dad were in a little wreck and it was a little fender bender and the child had a very small claim. Let's say $5,000 to $10,000, something small. That even if the parties settle out of court, meaning that the attorneys get involved, there's no petition filed, there's no complaint filed, all the dollar amounts are agreed upon, medical information is exchanged, the insurance carrier and the money can't be paid to the parents. A petition to compromise the claim of a minor has to be made, and in that petition it's made by one or both parents depending upon the custody situation, and the parents outline out the name, age, date of birth of the child, nature of the injury, the medical expenses and medical bills. Obviously all of this information is extraordinarily confidential, and because the information is confidential, the petition to compromise the claim of a minor must be filed under seal. There's a whole nother video that I should do on how to file things under seal, and especially in light of COVID-19, that process is changing. But essentially the petition outlines out all the medicals, all the injuries, any understanding of lifelong experience of pain that the child would have, why the number was determined that it was numbered, and how the money will be protected for the child for when the child turns 18. The money from the settlement for the child is supposed to go into a locked account, meaning that the money just goes in and it cannot come out without court order permission. Unfortunately, so many times the accounts are set up and they're not locked or blocked properly. And unfortunately, many times parents, caregivers, or others get at those funds so the child doesn't have the money. So the idea is that a lot of parents think, oh, well, I'm going to get this money and I'm going to use it for the benefit of my child while they're in their minority. And that's just not how it works. If you want to do that, you need to add it to the petition saying as to why you need access to the funds now. But generally speaking, the whole idea of NRS Chapter 41, Section 200 is to make sure that those monies for the child's personal injury are saved for a future date for when the child turns 18, then the child, once an adult, can decide what to do with those funds. But during the minority, courts need to or should control how the money is used. And the whole idea is to make sure that the child actually gets the money and not anybody else.